The United States Constitution is the supreme law of the land, but it was written with a built-in vulnerability. The words themselves are incredibly broad. Look at the text of the Fourth Amendment here. It protects citizens against unreasonable searches and seizures. But what exact police actions cross the line into unreasonable? Because the original authors didn't leave behind a precise legal dictionary, that vast gray area is left to 9 unelected judges to define. How they define those broad words dictates the rules millions of Americans live under every day. This immense responsibility creates a constant tension. Should the court exercise judicial restraint and defer to the laws passed by elected officials? Or should it embrace judicial activism, stepping in to correct social issues when other branches fail to act? Look back at the 1950s and 60s. The court, led by Chief Justice Earl Warren, actively struck down established state laws across the country to protect the civil rights of minorities. Reading the law requires an active deployment of philosophical power. The justices make deliberate choices that outline the boundaries of American life. To maintain a predictable legal system, the court relies heavily on stare decisis, a legal principle where past decisions act as precedent for future cases. This flowchart illustrates the concept. A single historical ruling acts as a foundational block. By tying future judgments to that original block, the court ensures that what is perfectly legal today doesn't suddenly become a crime tomorrow. But society evolves. When a past ruling becomes entirely unworkable, the court will step in. In 1954, Brown v. Board of Education explicitly reversed the separate but equal doctrine the court had approved decades earlier. Past cases provide a strong map for the present, but the justices are willing to redraw that map when an old ruling is recognized as an error. When historical precedent doesn't hold a clear answer, some justices turn to originalism. This philosophy reads the text to find the exact meaning understood by the people who ratified it in the late 18th century. By locking in those original definitions, the law remains stable. Unelected judges are blocked from inserting their own personal, modern beliefs into the rules. The trade-off is practicality. Critics argue it is incredibly difficult to govern a modern nation by exclusively consulting the worldview of people from over 2 centuries ago. It is a method that prioritizes strict legal predictability, accepting the friction of applying older logic to modern life. The contrasting approach is the living Constitution. This philosophy extracts the underlying values of the founders and applies them directly to modern situations, like internet privacy or surveillance from flying drones. Proponents argue that for a single document to survive hundreds of years of rapid technological and social change, it must breathe and adapt. But flexibility introduces a risk. If the meaning of the supreme law can shift depending on the decade, critics point out that judges can easily slide into writing their own laws from the bench. It gives the legal system the agility to handle modern crises, while demanding a high level of trust in the individuals wielding that interpretive power. Despite their life tenure, these 9 individuals do not operate in a vacuum. The broader political system places hard boundaries around them. Every justice must be nominated by an elected president. A constantly rotating Senate must confirm them, and Congress alone determines their budget and the exact number of seats on the bench. These structural constraints ensure that the judicial branch remains securely tethered to the rest of the elected government. If the court issues an interpretation of a federal law that the public rejects, the public has a direct recourse. Their representatives can simply rewrite laws to be more explicit. And if the ruling concerns the Constitution itself, there is a higher, albeit difficult, path. The public can amend the Constitution, completely overriding the court's interpretation. This document is the 16th Amendment, ratified in 1913. The Supreme Court had previously ruled that a federal income tax was unconstitutional, so the public legally changed the Constitution to allow it. The final meaning of the law is never an absolute decree from a bench. Instead, it is a continuous, evolving dialogue between the legal philosophies of the court and the will of the American people.